Hello, this is Rachid Elaafer again with IT Solutions Provider LLC in Medford, Massachusetts. Today's topic is HIPAA, H-I-P-A-A. HIPAA stands for Health Information Portability and Accountability Act. It is a U.S. law designed to provide privacy standards to protect patients' medical records and other health information provided to health plans, doctors, hospitals, and other healthcare providers. The good news is that most businesses have heard of HIPAA rules and regulations, but don't know if they need to take any action to be in compliance, or simply what does HIPAA means for their business. Does it affect their business or not? But first, let me read you the definition of HIPAA according to HHS, U.S. Department of Health and Human Services. Then I will break it down for you. The HIPAA rules apply to covered entities and business associates. I will discuss who are the businesses that are titled or called covered entities and what businesses are considered business associates. Individuals, organizations, and agencies that meet the definition of a covered entity under HIPAA must comply with the rules requirements to protect the privacy and security of health information and must provide individuals with certain rights with respect to their health information. If a covered entity engages a business associate to help it carry out its health care activities and functions, the covered entity must have a written business associate contract or other arrangement with the business associate that establishes specifically what the business associate has been engaged to do and requires the business associate to comply with the rules, requirements to protect the privacy and security of protected health information. In addition to these contractual obligations, business associates are directly liable for compliance with certain provisions of HIPAA rules. That is the definition listed by the HHS. The frequently asked questions are: who is under HIPAA compliance rules? Who qualified under the name of business associate? How do I find out if my business or organization is a HIPAA business associate? How do I find out if any of the organizations we work with are also HIPAA business associates? First question we'll answer: who is under HIPAA compliance rules? The answer is any healthcare providers that transmit health information electronically, directly, or through a business associate. Second question: who qualified under the name of business associate? If you are considered a business associate under HIPAA and High-Tech Act, you have substantial obligations to do. Because if you were investigated by OCR, Office of Civil Rights, and found to be neglectful in complying with these provisions under the HIPAA Omnibus Rule, you may find your organization subject to fines, penalties, and corrective action plans, which can be financially substantial and operationally difficult. Let's look at what defines a business associate in the HHS perspective. A person who performs a function or activity on behalf of or provides services to a covered entity that involves individuality identifiable health information. For example, an attorney or an attorney firm. In addition, business associate agreements would be required between 1. Covered entity and business associate A. 2. Business associate A and subcontractor B. 3. Subcontractor B and subcontractor C. And 4 is subcontractor C and subcontractor D. The contracts that you must include should have the following: permitted uses and disclosures, requirement to use appropriate safeguards, requirement to report of non-permitted uses and disclosure to covered entities, requirement to extend same terms to subcontractors or agents. Now let's talk about covered entities. A covered entity is one of the following: a healthcare provider, for example, doctors, clinics, psychologists, dentists, chiropractors, nursing homes, pharmacies, or a health plan, for example, health insurance companies, HMOs, company health plans, government programs that pay for health care, such as Medicare, Medicaid, and the military and veterans health care programs. A healthcare cleaning house. This includes entities that process non-standard health information they receive from another entity into a standard, for example, standard electronic format or data content, or vice versa. Who is not required to comply? The answer is a person or organization where access to protected health information is not necessary to do their job. For example, janitors, electricians, copy machine repair person, to name few. But if you are a covered entity, then you have to comply with these requirements. You need to obtain satisfactory assurance that business associate will appropriately safeguard protected health information. It is a written contract or other written agreement or arrangement. No monitoring, and cure or terminate contract if known violation. Now let's break Hipaa rules a little bit down. There are two main rules that are under Hipaa regulations: the privacy rules and the security rules. Let's look at the privacy rules first. It refers to the broad requirements to protect the confidentiality of protected health information, PHI, in all its forms. For example, a physician talking loudly on the phone in the lobby of a restaurant about a patient by name is a violation of the privacy rules. The security rules are specifically concerned about protecting the confidentiality, privacy, integrity, and availability of electronic records that exists in a digital form. So once you are dealing with electronic health records and information systems, violations tend to fall under the security rules. Here is another example that has both rules. when a patient filled the office visit form or when an office received a fax in a fax machine, it would fall under the privacy rules. However, if it is or if it was emailed or faxed as a fax service like eFax, then fax would be covered under the security rules because the data is digitalized. Therefore, if you are using a free email account like Yahoo, Hotmail, or Gmail, then you are under the security rules regulations, and quite frankly, you should not be using such accounts. Many businesses are overwhelmed with trying to meet all the federal program mandates and keep up with all the other changes. A question that comes more often is, what are the two things that all businesses should be doing right now to become compliant with the law and protect their business? It is a long answer, but I will try to make it simple and short. 1. The business need to have the required set of security privacy policies in place. Most businesses have some privacy policies in place, but are missing the security policies. For example, you need to have the following policies and procedures. A sanction policy. A named security officer in your organization. An information system activity review and audit procedure, and many others. Let IT solutions provider protect your organization. Hipaa Omnibus Rule enforcement is here. Permanent Hipaa audit programs began in 2014. Millions of patients' records have been breached. Increased Hipaa fines up to 1.5 million. All size organizations must comply with Hipaa nowadays. We perform your Hipaa and meaningful use risk assessment. We write your policies and procedures. We train your employees. You can access web-based compliance training with us.